Well, I have some questions about the specifics of the custody case. I'm the father of an 11-year-old son. I have visits with him right now, trying to get custody. And the problem is there's not really tangibles, not physical evidence, but to me it's more like mental, emotional abuse type things. Just how do I bring those things to light in court? And then is it true also that he does have to be 12 years old to be able to testify in court?
Well, there's a couple of questions there. Number one, if you're in a custody dispute and they're talking about, what harm has befallen the child, which could affect your co-parenting time, Megan.
Well, I think there's two scenarios here. One, if you already have a parenting plan, you're going to want to try to modify your parenting plan, and when you go to modify the parenting plan, you could put in there what your concerns are about the mental and emotional abuse that you think that your 11-year-old is facing. If you don't have a parenting plan already and you need to establish one, then when you go to file to establish one, you could do the same thing. File to establish a parenting plan and then put those same concerns in there and try to get them in front of the judge that way, or at mediation.
So when you're thinking about it, how can you do that during court or at trial, as we like to call it? You simply tell your lawyer, or you simply tell the judge, hey, I'd like to say a few things here, and they're going to take your testimony in turn, and they're going to give you the floor, so to speak, and you're going to have your time to air those things out. I would mention this. You mentioned something about how old does a child have to be to tell the court its preference? And really there's no specific age, but the law does say that children that are 12 and up, their preference will be given a greater weight, but it's only another factor for the court to consider in making a custody determination. So it's not the end-all be-all, but it does have a little more weight if the child is over 12. Now, there have been situations that I have been in where you have a 9-year-old or a 10-year-old, when they can articulate a little bit better, then sometimes the judges will bring them back into their office and will ask them outside of the courtroom so they can't feel like they're picking a side. Because when we go to juvenile court or we talk about things with custody and co-parenting time, the most important thing is the children. Every time. That's what the court's going to be focused on. That's what guardians ad litem or the child's lawyer is going to be focused on, is what's in the best interest of this child. And when you have a child that's 12-year-old, 13-year-old, well, their lives are changing and they're moving into those teenage years, and that schedule's not going to need to be as rigid as it was before then. So just keep that in mind, and I think things should work out for you.